All right. A federal judge just torched Trump's legal strategy from the inside out. Not one motion denied, not one attorney sanctioned. The entire framework his team built around Bondi's allies just collapsed in open court. And the judge didn't whisper it. He put it in writing. 47 pages, detailed, documented, devastating. I've been reading this ruling since it hit the docket. Page 11 alone stopped me cold. I read it twice, then a third time. Here's what the headlines aren't telling you. Trump's legal team has 96 hours to restructure before the next hearing. No negotiation, no grace period, immediate compliance, or the judge signals he's prepared to go further. And based on what's buried in this order, further means something very specific. I'll get to that. Quick background first. Bondi's allies. That phrase matters. These aren't random outside counsel. These are attorneys with direct professional histories tied to Bondi's network. They were brought in specifically to anchor Trump's litigation posture across multiple fronts. The theory was simple. Loyalty plus legal firepower equals strategic dominance in federal court. The judge just said the theory is broken. Here's the timeline. 6 weeks ago, opposing counsel in 2 separate federal matters filed preliminary conflict disclosures. Routine on the surface. But the language wasn't routine. The filings used phrases like structural entanglement and concurrent loyalty obligations. Legal terms that mean one thing in plain English. These attorneys can't serve 2 masters at the same time. 3 weeks ago, the judge ordered an in-camera review. Private, sealed, no press, no public, no leaks, just the judge, the documents, and the evidence both sides submitted. Last Thursday, a closed hearing. Emergency designation. Both legal teams present. No transcript released publicly. Monday morning, this order dropped. That's the setup. Now the substance. What makes this ruling different from standard conflict motions isn't the outcome. Disqualifications happen. They're uncommon, but they happen. What makes this different is the architecture of the judge's reasoning. He didn't find one conflict and extrapolate. He mapped a network. Page 9 through page 21, 12 pages of documented connections. Same firms, same prior representations, same financial relationships. A web the judge called, and I'm pulling from the order directly here, a deliberately constructed arrangement that prioritized strategic alignment over ethical independence. That's not judicial frustration talking. That's a finding of fact. The judge is a Clinton appointee, worth noting, but before you file that away as a partisan observation, keep reading. His 3 prior rulings in cases touching this administration went 2 for 1 in the administration's favor. He's not reflexively hostile. Which means when he writes 12 pages mapping a conflict network, that document survived his own internal scrutiny. Page 14. This is where it gets precise. The order identifies the lead attorney on Trump's team as having maintained, quote, active co-counsel arrangements with firms representing direct adverse parties in matters connected to this litigation cluster. Connected matters. That phrase is doing heavy legal lifting. It means the conflicts don't stop at the case in front of him. They radiate outward across related proceedings. What does that mean practically? It means every strategic decision made by this team in the last 4 months is now under scrutiny for potential taint. Not just here, across the cluster. I went through the exhibit list. 290 pages. Depositions, billing records, emails with timestamps, retainer agreements going back 26 months. The judge didn't build this ruling in a week. He's been assembling it since the in-camera review request landed on his desk. Here's what buried most people. Page 33, footnote 11, the judge references internal communications produced during the sealed review, showing that at least 2 members of Trump's legal team were flagged by their own firm's conflicts department before taking on this representation. Their firm's internal system identified the issue. They proceeded anyway. The judge's exact language on this point is careful but unmistakable. The court notes the existence of internal advisories that were not disclosed during the initial conflict screening process submitted to this court. Read that twice. They had internal warnings. They didn't disclose them to the judge during the standard screening. The judge found out anyway. That's not an oversight. That's a choice. And the judge is treating it like one. Now the response. Trump's team filed an opposition brief within 6 hours of the order, 22 pages. The argument structure goes like this. First, the conflict rules in question have recognized exceptions for coordinated government-adjacent litigation. Second, the prior representations involve different matters in different jurisdictions. Third, the judge applied a standard of review more typically used in criminal proceedings, not civil federal matters. Here's the tell. The brief spends 14 of its 22 pages arguing about the standard of review. It spends almost no time disputing the underlying facts. When your legal team writes 22 pages and 14 of them are about process rather than facts, they're telling you something. They're telling you they can't win on the facts. And here's what I want you to sit with for a second. The attorneys filing that opposition brief, some of them have the same firm affiliations the judge just spent 12 pages documenting, which means part of the conflict the judge identified is still actively present in the room arguing against his ruling. He noted that. Page 38, the court observes that the opposition brief was filed by counsel whose own conflict status under the terms of this order remains unresolved, pending further review. He flagged it in real time, in the order responding to the opposition. That is a judge who is not surprised by anything this team does and is documenting it as it happens. Now, the case is in limbo. 4 matters are currently stayed pending resolution of the counsel crisis. Not 3, 4. And the scope is wider than initial reporting suggested. The first is the financial fraud enforcement action. 8 corporate defendants, combined exposure exceeding $200 million. Trial was 55 days out, now frozen. The second is the regulatory challenge matter. This one involves a federal agency rulemaking that affects an entire industry sector. The case has been building for 18 months. It was approaching a ruling on summary judgment, now paused. The third is the civil contempt proceeding. This one matters differently. It's not about money or regulation. It's about compliance with a prior court order. The judge in that matter, a separate judge in a separate district, has now issued a hold pending resolution of the conflict ruling. One judge's findings creating a chain reaction in another courtroom. The fourth matter, this one is still partially sealed. The public docket entry shows only that it involves, quote, matters of significant federal interest with national security adjacent implications. The judge in this order references it twice in footnotes but doesn't name it directly. That's deliberate. He knows what he's referencing. He's keeping it quiet for now. 4 cases, 4 different exposure profiles. All of them stalled because the legal team at the center collapsed under the weight of its own conflict history. Now, here's what nobody is covering properly. Tuesday afternoon, a new filing appeared. It wasn't from Trump's team. It wasn't from the court. It came from a third-party watchdog organization that had been tracking the Bondi network connections for 8 months. They filed an amicus brief requesting permission to submit supplemental evidence to the court. Evidence they claim expands the conflict map beyond what the judge already documented. The judge hasn't ruled on whether to accept it yet, but he hasn't rejected it either. And the fact that he hasn't rejected it means he's reading it. If he accepts that brief, the conflict map gets bigger. If the conflict map gets bigger, the number of state cases gets bigger. If that happens, we're not talking about a legal team in crisis. We're talking about a litigation strategy that has to be rebuilt from scratch across multiple federal fronts simultaneously. One more thing buried in this order before I get to what the experts are saying. Page 44. The judge reserves the right to refer specific attorneys for bar discipline review in their respective state jurisdictions. He identifies 3 of them by name. He uses careful language. He says the conduct documented herein warrants review by the appropriate professional responsibility authorities. He does not say they did something wrong for bar purposes. He says it warrants review. That's a referral trigger, not a conclusion. In practice, what that means is 3 attorneys on Trump's legal team may now be fielding ethics inquiries from state bars in addition to managing the fallout from this order. That's not hypothetical. That's how these referrals work. The judge writes the language. The bar's process takes it from there. Let me show you what the legal community is actually saying, because this part matters. A former federal appellate judge with 19 years on the bench, not associated with either party, put it this way. I've reviewed conflict disqualifications across 4 decades of federal practice. The scope of what this judge found and the evidentiary foundation he built, that's not common. That's a judge who was determined this would survive appeal. A legal ethics scholar at Columbia, someone who's written extensively on government attorney conduct. The internal conflict warnings that were not disclosed to the court, that's where this gets serious. Conflict findings are appellable. Non-disclosure findings carry different weight entirely. A former deputy attorney general who served under 2 separate administrations, one from each party. The 96-hour replacement window is aggressive. I won't call it unreasonable given the documented non-disclosure. But finding replacement counsel with the right clearances, no prior entanglement with this specific network, and the willingness to step into this environment, that's genuinely difficult. That's not spin, that's operational reality. A conservative constitutional attorney affiliated with major Federalist legal organizations, the judge may have gone further than necessary on the network analysis. But the core finding, actual conflict supported by documented internal advisories that were withheld from the court, that core is durable. I would not expect that part to fall on appeal. That last voice matters. When someone whose ideological alignment runs toward the administration being challenged says the core is durable, that's an honest assessment of legal exposure, not political theater. Legal exposure. Here's where the other side has legitimate ground. The 96-hour window. Aggressive isn't the right word. Brutal might be closer. Finding qualified federal litigators with proper security clearances, no connection to the Bondi network, and enough familiarity with 4 complex federal matters to walk into court ready to proceed, that's not a 96-hour job under normal circumstances. The opposing counsel who raised these conflicts did so at a calculated moment. Both matters that were closest to trial had hard deadlines in the next 45 days. The conflicts were knowable months ago. The timing of the motion is strategic, almost certainly. The judge acknowledges this on page 19. He writes that the court is aware that the timing of these motions coincides with critical procedural junctures. But then he says something the DOJ defenders don't quote. The strategic timing of a legitimate challenge does not transform the challenge into an illegitimate one. He saw the strategy, he evaluated it, he ruled anyway. There's also a jurisdictional question worth taking seriously. The conflict standard the judge applied draws from a line of cases that not every circuit follows uniformly. The appeals court in this circuit has ruled on conflict matters twice in the last decade, both times in favor of the challenging party. But neither case involved the specific combination of factors here, which means the appeals court will be writing on something close to a clean slate. The government's strongest appellate argument isn't about the facts. It's about proportionality. Even if conflicts exist, was disqualifying the entire team across 4 matters the right remedy? Couldn't less drastic measures have worked? Screens, waivers, partial disqualifications? The judge anticipated this argument on page 41. He writes that less restrictive remedies were considered and rejected because the structural nature of the conflicts makes targeted remediation insufficient. When the conflict is architectural, you can't just redraw one wall. The appeals court will evaluate that reasoning, and the outcome is genuinely uncertain. That's not hedging, that's honesty. This could go either way at the appellate level, but it has to get there first. And while the appeals court considers it, the 96-hour clock runs. Let's talk about what this actually means for real people, not just legal strategy. The financial fraud enforcement matter. 8 corporate defendants, every one of them has employees, shareholders, supply chain partners, whose outcomes depend on resolution. This case freezing doesn't just affect the defendants. It affects workers at those companies waiting to know if their employer survives federal prosecution. It affects investors in pension funds and index funds with exposure. It affects competitors who've been operating under uncertainty about whether the market will be reshaped by the outcome. The regulatory challenge matter. An entire industry sector. Think about what it means when a case challenging a federal agency rule freezes in the middle of summary judgment proceedings. Companies that structured compliance programs around the anticipated outcome now have no timeline. Compliance investments made on a projected schedule are now hanging. The civil contempt proceeding? This one hits differently emotionally, because contempt proceedings exist to enforce prior court orders, which means there's already a finding that someone violated a judicial order. And now the enforcement mechanism is stalled. The people that prior order was meant to protect are waiting longer. That's not abstract legal process. Those are real outcomes for real people inside a system that's now been disrupted by a conflict the attorneys involved were warned about in writing before any of this started. Here's the uncomfortable thing that gets lost in the political noise. What happened here isn't unique to this administration's approach. Every administration uses the revolving door. Government service feeds private practice, feeds government service. The network of firms, former officials, connected counsel, that's not new. It's not a feature of one party or one ideology. It's a structural reality of how federal legal work gets done in America. What this judge did Monday is draw a new line. A line that says, The network of connections that used to be tolerated has moved past what the ethics rules will accommodate. Not because the rules changed, because the connections got too concentrated, too documented, and too specifically tied to active adverse representations. That line affects everyone in federal litigation. Not just this team, not just this administration. The attorney in a civil case 6 months from now who has a tangential connection to a prior client's competitor, the government lawyer who left a firm 2 years ago and still has equity interests in client work she didn't personally handle. This judge's reasoning will be cited, it will be argued, it will shape conflict analysis in federal courts for years. That's not doom. That's how legal precedent works. But it means the assumptions that governed how legal networks operated in federal practice may need to be re-examined more broadly. If you work with attorneys who handle federal matters, civil or criminal or regulatory, the right question to ask right now is simple. Does any of this apply to us? Not accusation, not panic, just due diligence based on a new and documented interpretation of what the conflict rules require. Where does this go from here? The 96-hour deadline is Thursday. Trump's team needs to present replacement counsel to the court. Attorneys with clean conflict profiles, appropriate clearances, familiarity with matters complex enough that 4 separate federal cases depend on their competence. The judge made clear on page 46 that proposed replacements will be subject to expedited conflict screening conducted by the court itself. Not just by the parties. The court is vetting the replacements. He's not letting another team walk in unchecked. Wednesday at 5 p.m., the DOJ sanctions motion response is due in the ancillary matter. That filing will be the first clear signal of Trump's team's strategic posture going forward. Are they going to fight on substance, concede the facts and argue process, request further delay? That response will tell you more about Thursday's hearing than anything the spokesperson says in public. The appeals court has been silent since the emergency stay petition landed Monday evening. Every hour of that silence is information. A stay granted early is a stay that saves the Thursday hearing. A stay granted late compresses everything. A stay denied means Thursday becomes the most consequential hearing of this administration's legal tenure. And that third-party watchdog brief. If the judge accepts it, we're looking at potential expansion of the conflict map before Thursday's hearing even begins. Expansion means more cases, more stays, more attorneys facing scrutiny. The judge has shown he's willing to move decisively. An expanded evidentiary record gives him more runway. Here's what I'll be watching specifically. Whether the appeals court moves before Wednesday at noon. That's the window. If they're going to grant an emergency stay before Thursday, they need to do it with enough lead time for the Wednesday briefing to be paused too. After noon Wednesday, the timeline gets too tight for an orderly stay. The language in the sanctions response, not the conclusion, the language, whether the brief engages directly with the judge's factual findings or circles around them. The circles tell you more than the direct arguments. Whether any of the named attorneys proactively reach out to state bar authorities before a referral lands. Proactive disclosure changes the bar process significantly. It doesn't eliminate it, but it changes the trajectory. And whether additional third-party watchdog organizations or amicus parties join the filing queue. The first brief got filed. If others follow before Thursday, the judge has a public record of outside entities supporting his evidentiary framework. That matters for the appeal. Here's where everything stands right now. Monday, a federal judge issued an order that disqualified Trump's legal team built around Bondi's allies. He did it immediately. No stay, no pause for appeal. He cited documented internal warnings that were withheld from the court during conflict screening. He mapped a network of connections across firms, clients, and active adverse representations. He flagged the potential for bar referrals. And he scheduled Thursday's hearing not just to review replacement counsel, but to consider supplemental remedies. Supplemental remedies. That phrase is doing the most work in this entire situation, because it means whatever happened Monday is a floor, not a ceiling. The judge has reserved the right to expand consequences. He hasn't defined what that expansion looks like. He doesn't have to yet. Thursday gives him the opportunity. Trump's team filed 22 pages of opposition in 6 hours and couldn't dispute the facts. That's the tell. Their appeal, if it gets there, lives or dies on proportionality and standard of review, not on whether the conflicts existed. They existed. or the appeals court writes an entirely different one before then. Either way, I'll be in the documents. Subscribe and turn on notifications. This doesn't follow a news cycle. Filings drop at midnight, orders hit dockets at 6 a.m. The story moves when the story moves, not when the cameras are ready. And here's the part that keeps pulling me back to this story. The judge didn't have to go this far. He had options. Narrower remedies, targeted disqualifications, waivers with conditions, screens that wall off the conflicted attorneys from specific case decisions. These are standard tools. Every federal judge handling a conflict motion knows the menu. He looked at the menu, he ordered something that wasn't on it. That tells you something about what he found when the sealed review was complete. When a judge with 290 pages of exhibits, 4 internal advisory memos, documented non-disclosure, and a mapped network of firm connections bypasses every moderate remedy and goes straight to full disqualification across 4 matters simultaneously, he's not improvising. He's sending a message that the evidence made the moderate options feel inadequate. Page 23, this one line, I keep coming back to it. The court finds that the cumulative weight of the documented conflicts renders any partial remedy structurally insufficient to protect the integrity of these proceedings. Cumulative weight. That means it wasn't any single conflict that broke the threshold. It was all of them together, the network as a whole. Not one bad connection, but a pattern so pervasive that cutting one thread wouldn't untangle the web. That's a specific and deliberate legal conclusion. And it's the hardest part of the ruling for Trump's team to attack on appeal. Because you can argue about one conflict being overstated. You can argue about the applicable standard for one attorney's prior representation. But when the judge says it's the cumulative pattern that drives the ruling, you have to attack the entire map, all 12 pages of it, every connection he documented, every firm relationship, every time-stamped payment in the billing records. That's not a motion. That's a campaign. And you have 96 hours. The replacement counsel problem is real, and it is being severely underreported. This isn't a situation where Trump's team calls a few well-connected law firms and slots in new names by Wednesday evening. The judge was explicit on page 46. Proposed replacement counsel must submit to expedited conflict screening administered directly by the court, not a self-certification, not a party disclosure, the court itself running the check, which means the judge is personally reviewing whoever gets nominated to replace the team he just removed. He knows what to look for. He built the conflict map. He knows every firm name, every prior client relationship, every financial connection in the network. Anyone who walks through that screening process with even a thread connecting them to what he documented is going to get flagged before they ever set foot in a courtroom. This is the corner Trump's legal team is sitting in right now. The judge who removed them is also the judge vetting their replacements using the same evidence that got them removed. Thursday is not just a deadline. It's an audition in front of the most informed audience in the building. That's where we are. So let's land this plane properly. Monday changed something, not just in these 4 cases, not just for this legal team, not just for this administration. Monday changed the operational assumptions that have governed how politically connected legal networks function inside federal litigation for decades. A judge read the internal warnings. He reviewed 290 pages of documented evidence. He mapped the network connection by connection, firm by firm, payment by payment. And then he wrote 47 pages explaining exactly why none of it was acceptable and exactly why the moderate remedies weren't enough. That document exists now. It's public record. Other judges will read it. Other defense attorneys are already reading it. The legal world doesn't forget a ruling this architecturally detailed. It gets cited. It gets argued. It becomes the reference point in the next conflict motion, filed in a federal court somewhere in this country. Thursday at 10 a.m. Eastern is the next visible moment. But the real story is already written in the exhibits, in the OPR memos, in the billing records with timestamps, in the emails produced during sealed review. In the footnote on page 44, where a federal judge quietly reserved the right to refer 3 attorneys for bar discipline without making it the headline. The headline was the disqualification. The story is everything underneath it. I'll be here when the appeals court rules. I'll be here Thursday morning when replacement counsel either passes the judge's screening or doesn't. I'll be here when the sanctions response drops Wednesday and signals which direction this fight is actually heading. Subscribe, notifications on, this one isn't done. The documents tell the story. I just translate them. And right now, the documents are saying Thursday is only the beginning. Stay connected, because what started Monday is not close to finished.